Ah, hello, welcome, and a look at how cases can be terminated without the misery and the great expense, of course, of going to trial. A number of aspects today, the immensely expanding scope of abuse of process, summary judgment, of course, failure to comply with unless orders. Some really interesting stuff there, including one case, arguably worth millions, where the claimant got home and dry because the defendant didn't comply with a disclosure order. I'll say something about dishonesty. On fundamental dishonesty, I mean, that, of course, is a matter which ultimately does go to trial, but I thought for sake of completeness, I should include it. And because the beauty for a defendant on fundamental dishonesty is that the claimant, the winner, loses because they win, but then they don't get any damages because of their fundamental dishonesty. So I thought for sake of completeness, I do with that. Protocols, again, we're going to look at very soon, massively important, and new protocols in the pipeline, I understand, for 2024. So a number of things. Now, on the point of service, just say at the outset, I am looking at viable matters that certainly get issued and sort of get off the ground, but don't go the distance. The point about service, but I have advocated that the service rules should be rewritten top to bottom, because nobody listens to me, is that if there is a fundamental failing on service, there are no proceedings, so claim no action, and therefore that is it. So it really is fatal to get it wrong on service. Those of you, I'm sure there are thousands of you who follow Gordon Exall's civil litigation brief every month, in fact more frequently than that, there is another sob story about service. And really, it's very easy for me to say because I don't practice, but the number one thing is don't leave service to the last minute. And the moment that you have issued proceedings, think of them, think of proceedings as, you know, like a little time bomb ticking away. And the sooner you get it off the premises and get it to the correct defendant, which is an art in itself, making sure that you have got the right defendant and, you know, not serving on solicitors when they've never indicated they were authorized to accept service, then you know what, the decks are cleared and you can sleep at night. But anyway, with that sort of a warning there, let us get down to business. And just on service, by the way, do read, because the law is, as I've said, an unholy mess. But the Boxwood judgment that I refer you to here pulls all of the strands together beautifully. Very illuminating indeed.